Bennett.
1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20. Now 21 cases.
Okay, pause. This judge is rapid firing charges like he's reading a grocery list from hell. Notice how he's stacking possession, unauthorized use, evading. This is what's called charge stacking, and it instantly raises the stakes of the defendant.
Just since 2020, possession 1 to 4, unauthorized use, possession 4 to 200, 21, evading arrest, felony theft, felony assault, felony possession of a controlled substance, possession of a controlled substance, possession of a controlled substance, now 24, possession of a controlled substance, possession of a controlled substance, assault.
Classic courtroom rule. Never interrupt the judge, especially this judge. The moment Price speaks out of turn, she shuts it down instantly. Judges do this to maintain order and also because they absolutely can.
Unauthorized absence from correctional facility, PCS, now 25, just from 25, PCS, unauthorized use, and now you have an evading arrest.
A lot of those guys.
Stop. I didn't ask you to say anything. You missed court, and now you're here. If you ever miss court again, and let me tell you something, Mr. Price, I'm going to do everything in my power to protect my city at all costs. If I find that you are one iota of danger to it, it's really not going to go well for you. Do you understand me? You're now charged with evading arrest or detention. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Thank you, Judge. On April 14th, 2025, in Harris County, Texas, an officer was patrolling the area of 999 Pasadena Boulevard, the Macro Plaza Mall. The mall is closed during the early morning hours when this incident occurred, and no maintenance or cleaning personnel were on scene.
Right here is where the probable cause drama starts. The officer sees suspicious behavior, which is one of the most debated phrases in police reports. Comment below. Do you think riding a bike near a closed mall is suspicious or just existing?
999 Pasadena Boulevard is near 1202 Pasadena Boulevard, which the officer knows from training and experience to be a high drug area. The officer observed the defendant standing near a mechanical box on the side of the main building of 999 Pasadena Boulevard. The defendant looked at the officer, who was in a marked patrol unit, and began walking toward his bicycle, which was laying on the ground nearby. Due to the above circumstances, as well as defendant's suspicious behavior, the officer initiated a subject stop on the defendant due to reasonable suspicion.
Phew, plot twist. The judge just nukes the whole case with no probable cause. This is big. Judges rarely make that call so quickly unless the evidence is paper thin. This is why probable cause hearings matter. They stop weak arrests from becoming real charges.
The officer activated emergency traffic lights and began sounding the siren of a marked patrol unit. The defendant continued to ride his bicycle away from the officer, standing up on the seat of his bicycle to accelerate faster. The defendant eventually fell off the bicycle and continued to evade on foot until he fell in the roadway of the 900 block of Pasadena Boulevard. The defendant evaded the officer for approximately 736 feet.
The hell was he doing wrong? Riding a bicycle while white? He's not doing anything. Just presumptive police. No. Mr. Price, I'm going to find that there's no probable cause in your case today. We have enough death, dismemberment, and danger in our town as it is. Don't create any more. Be a good person. It's not hard. Get a job, do something with your life before something, or you end up with a 25-year sentence. It's lickety split. Something happens. Life is too short to end up in a 6x9 with a 25-year sentence. You know what I mean? Really. Please take a seat.
Good morning.
Ma'am, you're charged with assault, causing bodily injury. You're facing up to a year in jail and or a $4,000 fine. you have worked out an agreement where they're offering you 3 days in jail with credit for the 1 day that you've done. You need to understand that you're making a lifetime decision today where this assault is going on your record and it will be there for the rest of your life. You can never take it off. From now on, you'll be facing a minimum of 90 days in jail for any new cases that you pick up. Do you understand?
I'm facing 90 days.
If you pick up any more cases,
Oh, yes, sir.
you'll be facing a minimum of 90 days in jail.
Yes, sir.
You're giving up the right to, is this on doctor? It's on doctor. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization, you give up the right to appeal. Once you accept this agreement, you can never change this or undo this. You understand?
I do understand that.
This isn't like Target where you don't like it, oh man, this is hurting, you can return it. No, once you plead guilty, it stays with you forever, you never change it. If you're not guilty, don't plead guilty. It's just that simple, really, don't, because you'll always live with regret.
Sir, I was assaulted first.
I can talk to you about that case. Right? You're telling me that it's self-defense?
A child a day.
Yeah. What do I do?
She's gonna show up.
She won't.
Excuse me. I'm happy to give you more time to discuss it, just, it's probably not best here. I live stream, so.
We will for tomorrow, Your Honor.
Sure.
Okay, thank you, sir.
Morning, Mr. Tolentino.
Morning.
Sir, you're charged with illuminating an aircraft with a laser pointer. You're facing up to a year in jail and or a $4,000 fine. The agreement that you have worked out is a 6-month deferred adjudication. This is a very serious agreement that you're entering into now.
This section is wild. The judge is basically giving the defendant the don't mess this up probation speech. Deferred adjudication is a golden ticket. Do everything perfectly and you dodge the conviction. But mess up once and boom, full year in jail. High risk, high reward.
This is a type of probation that if you complete successfully, you do not end up with a conviction on your record, but you cannot tell people it was dismissed. It doesn't get dismissed. You do a probation, complete it successfully if you do, and you don't end up with a conviction. Do you understand the difference? You give up nearly every right known to man by entering into this agreement, telling us that you can complete this. And if you don't, you're facing an entire year in jail. Do you understand? You're giving up a lot of rights. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this agreement, you are stuck with this until you complete it successfully or it gets revoked. If you do something to violate this agreement, like you pick up a new case, you don't do your class on time, you don't do your community service, I'm going to issue a warrant for your arrest, and we're going to have a hearing to see if you violated. If you do, you're looking an entire year. Do you understand? You still want to do this?
Yes, sir.
How do you plead to the illuminating an aircraft with a laser pointer improperly? Guilty or not guilty?
Guilty.
I'm not going to find you guilty. I'm going to withhold it for 6 months. You will do an effective decision-making class, thinking for a change, no drugs, alcohol, 25 hours of community service. Did you graduate from high school? Okay, what are you doing now?
Electrical. I do electrical.
Huh?
Yeah.
Okay. I want you to maintain full-time employment while you're on probation as well. I'll make you a deal. If you do well, you get everything done quick. I'll take you off in half the time, meaning get your classes done, be nice to everybody. And if you do that, we can take you off in half the time as a reward. But if you mess up, it's not going to go well. Do you understand?
Sir.
All right, bud. Good luck to you, sir. Thank you, Judge. Thanks, Joe. Okay. Mr. Aguilar, you're charged with failure to stop and give information striking a highway fixture You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You're also charged with theft, a Class A misdemeanor where you're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. Law enforcement officer spoke with the complaining witness who stated that on April 2nd, 2025, he parked his truck in his company's parking lot, locked the truck, and when he returned the next day, his tailgate was missing. An employee of the complaining witness searched Facebook Marketplace and found a tailgate that matched the complaining witness's stolen tailgate and had recently been published. The law enforcement officer executed a sting operation to purchase the tailgate from the defendant, the seller, on Facebook Marketplace. He paid the defendant $140 for the tailgate. The defendant was subsequently arrested. The complaining witness stated the price to replace the tailgate was $1,117.65. The defendant stated he buys the tailgates from a friend for $75 and resells them for typically $300 to $400.
Okay, this is where the legal nuance gets juicy. Selling stolen property isn't automatically theft. The prosecution must prove you knew it was stolen. That's mens rea, aka criminal intent. Watch how the judge pushes the DA to show actual evidence, not assumptions.
We have him taking the actual tailgate, right?
Yes, Your Honor, that's what it says. Well, it has him as the seller of the tailgate.
Yeah, I didn't take the, Your Honor.
Stop. Don't say anything. You have the right to remain silent. Exercise that right.
Yes, Your Honor, it has him as the seller and that it was recently published 2 hours ago on Facebook Marketplace. But those are the facts as far as the dim summary goes.
It says here that this defendant did then and there unlawfully appropriate by acquiring or otherwise exercising control over property, namely a tailgate owned by Jonathan Smith. Did he take the actual tailgate?
Your Honor, there are no facts alleged in the DEMS that he knowingly took the actual tailgate. However, the tailgate was in his possession and under his control.
Sure.
He was the seller on Facebook Marketplace. There's no information in the DEMS, though, that represents that he was the actual individual that stole the tailgate. In fact, when the officers interview him, he says that a friend, he buys the tailgates from a friend and then resells them on Facebook Marketplace.
Are we to assume that he knows that they're stolen? You know, he's charged with theft, right?
Sure.
It's a specific intent crime. So if he's selling stolen property, somehow there has to be evidence that he knows that it's stolen. How do we know that he knows it's stolen? We don't operate on hunches.
Your Honor, there is also an allegation, or it's alleged in the DEMS that the defendant told the law enforcement officer that he was aware the tailgate was stolen.
Well, there you go. Okay.
Thank you. It's my fault.
Mr. Aguilar, I'm going to find that there's sufficient probable cause to go forward in the theft case. What about the failure to stop and give information?
Failure to stop and give information.
Let's see. We need to do probable cause on that one as well, please.
Good, Your Honor.
Yep.
The law enforcement officer was following up on this case in the original report. The defendant's vehicle struck a metal gate at an apartment complex. A witness looked out her window and saw the suspect vehicle and photographed the driver and passenger as they exited the vehicle. Law enforcement officers ran the plates and had the vehicle and owner information. The law enforcement officer later observed the defendant's vehicle in front of the residence. The vehicle had significant damage to the hood. The law enforcement officer made contact with the driver, the defendant. The defendant was ID'd to be the vehicle owner. The defendant stated he loaned his vehicle to an acquaintance he only knows through Instagram. The defendant showed the law enforcement officer the man's Instagram named Go Get a Veil. The defendant claimed that this man needed to borrow the car to pick up a girl. The defendant stated he would obtain the man's real name and provide it to the law enforcement officer by the end of the day. The law enforcement officer was not contacted by the defendant again. The law enforcement officer took a still shot on his body-worn camera of the defendant during the conversation. The law enforcement officer later compared the photos and saw the defendant was the same as the photo from the reportee. The law enforcement officer attempted to contact the defendant and could not. The apartment complex's estimated damages are $2,000.
Got it. Mr. Aguilar, I'm going to find that there's sufficient probable cause to go forward on both of your cases. Can you tell me if he has a license to drive, please? Texas driver license.
John, can you check that on Aguilar?
Don't. I know that you are itching to say stuff. Don't.
Oh, no,
You
no,
have
sir.
the right to remain silent. Exercise. I've got a bunch of DAs here. Whatever you say, they're going to use it against you. So just now's not the time to fight your case. You will have the opportunity to fight it. Just now's not the time. I want you to understand, Mr. Aguilar, I will do everything in my power to protect my city at all costs, including property. And if I find that you're a danger to my city,